Hi, I'm Jim Frazier, CEO of Program Insurance, and here's your squared away, be in the know. Did you know that setting clients' expectation through the engagement process and the engagement letter significantly reduces the liability you may have arise from that engagement? I see a lot of times that companies use fairly loose language in their engagement letters, and by not defining the client's expectations, you let the client define their own expectations with something that they would find fault with the work product you did, which you may consider well outside of the expectations of the agreement. But if you don't set those expectations accurately and have both your firm and the client accepting those, you create a lot of liability. Anyone who has had any litigation experience here in the United States in particular knows that having things buttoned up when you go into court is the best way. You've set the client's expectations and they've agreed to that. And then when they come into court outside of those expectations, it gives you a significantly greater place of defense. We had a situation a couple years ago. One of our policyholders did a valuation around estate planning, and 2 years later the client utilized that same valuation for an M&A transaction. They were selling their company and ended up erupting into litigation 2 years after that, and we defended our policyholder as a result. And it really came down to the fact that there was not strong enough language where the client agreed in the original engagement letter that not to use it, nor would there be any liability arising from using it for any other unintended purpose. So this is very, very, very simple, but it can have very, very strong and damaging consequences to overlook it. So being squared away means being in the know.